School professionals are very skilled at giving information. After all, the free flow of information is essential to being an effective teacher or guide. However, some information should never be shared without parental consent. The Family Education Rights and Privacy Act of 1974, or FERPA, is a law that ensures parental access to their children's education records while protecting the confidentiality of those records from third parties without parental consent. Which brings to mind an obvious question. What are education records? FERPA defines education records as containing information that is directly related to a student, and being maintained by an educational agency or institution, or by a party acting for the agency. These records can be in any media form, such as handwritten, typed, microfiche or microfilm, or electronic format. It's also helpful to know what are not considered educational records according to FERPA law. These include law enforcement records, employment records, medical records, alumni records, and sole possession records. Sole possession records are records that are kept in the sole possession of the maker, used only as a personal memory aid, such as teacher reminder notes about a student, and not accessible or revealed to any other person except a temporary substitute for the maker of the record. In short, school districts are responsible for ensuring that all parents and eligible students over 18 years of age or in college are afforded all the rights provided them by FERPA. It's important that all staff who interact with eligible students be thoroughly familiar with FERPA law. While FERPA generally requires written parent or eligible student consent before disclosing education records, FERPA gives schools and districts flexibility to disclose related personally identifiable information in limited circumstances. FERPA violations can have serious consequences for school districts that fail to comply. Not only will non-compliant school districts be required to implement an action plan to ensure compliance, they also risk losing federal education funding. And there's always the risk of a complaint filed with the U.S. Department of Education. This course is designed to teach school staff members about FERPA and to describe the rules and procedures they must observe to comply with the law. By the end of this course, you'll be able to describe the FERPA law and its consequences, discuss the importance of confidentiality, explain the rules governing disclosure of students' personally identifiable information, and summarize the rights of parents and eligible students to access and review education records maintained by the school district. At the end of the course, you will have a chance to apply what you've learned during a brief quiz. So if you're ready, let's begin. Much of FERPA law is centered around the concept of disclosure. Disclosure means to permit access to, or the release, transfer, or other communication of personally identifiable information contained in education records to any party by any means, including oral, written, or electronic. There are lots of ways that a school employee can violate the disclosure principle of personally identifiable information. And even though it's unintentional, it can still create liability for the district. Examples of personally identifiable information include, but aren't limited to, student's name, parent's name, address of the student or student's family, identifying information like the student's social security number, student ID number, date of birth, place of birth, or mother's maiden name, and a list of personal characteristics or other information that would make the student's identity easily traceable. School districts have even unintentionally disclosed personally identifiable information in the context of research. Research data for a third party that's easily traceable to a particular student can violate FERPA law if appropriate steps are not taken. School districts should use generally accepted statistical methods to make sure any data reported from research prevents the identification of students. If personally identifiable information is removed before disclosure, education records can be released without the prior consent of the parent or eligible student. Under FERPA law, schools may disclose, without consent, a category of data called directory information. Some examples of directory information include a student's name, address, phone number, email, photograph, date and place of birth, honors and awards, and dates of attendance. However, schools must tell parents and eligible students about directory information and allow them a reasonable amount of time to request that the school not disclose directory information about them. If a parent requests that their child's information not be disclosed as directory information, the parent's request should be documented and become a part of the student's record. The request should also remain in force until the parent notifies the district in writing to have the request removed. An exception regarding the release of personally identifiable information without parental consent involves school officials within the school district who have legitimate educational interests. Districts can specify who is a school official within the district. School officials often include a teacher, school principal, attorney, accountant, human resources professional, information systems specialist, or support or clerical personnel. Contractors, consultants, volunteers, or other third parties, such as law enforcement units, may also be considered school officials. Schools and districts can disclose education records without prior consent to these officials, provided that they perform an institutional service or function for which the school or district would otherwise use employees, are under the direct control of the school or district with respect to the use and maintenance of the education records, are subject to FERPA's use and redisclosure requirements, and satisfy the criteria specified in the school or district's annual notification of FERPA rights for being school officials with legitimate educational interests in the education records. Many schools and districts have their own security units to monitor safety and security in and around school campuses. In FERPA, these entities are called law enforcement units. These units can include individuals, offices, departments, or divisions that are officially authorized to enforce laws or maintain the school's physical security and safety. FERPA regulations require that local education agencies give an annual notification to parents and currently enrolled eligible students of their rights under FERPA. While the law does not require personal notification to individuals, FERPA does require education agencies to provide this notification in a way that's reasonably likely to inform them of their rights. There are other exceptions to the prohibition against the release of personally identifiable information without parental consent. These include working with the appropriate officials in emergencies relating to safety and health, complying with lawfully issued subpoenas or judicial orders, providing requested information to administrators of another school district into which a student seeks to enroll or transfer, providing information to certain authorized federal officials or state or local educational authorities, disclosing information for financial aid applications or the receipt of financial aid awards, disclosing information to local or state authorities who are authorized to receive it under state statute, often for juvenile justice purposes, for academic research by educational institutions for educational purposes, to accrediting organizations to carry out their functions, and any disclosures related to sex offender registrants. The Health Insurance Portability and Accountability Act of 1996, or HIPAA, ensures privacy with respect to the electronic sharing of health information. Sometimes the question arises for school professionals which federal law matters more, HIPAA or FERPA. Generally, HIPAA excludes information considered education records under FERPA law. This information includes student health and immunization records that are maintained by the school or district, school nurse and medical records relating to students receiving services under the Individuals with Disabilities Act are also subject to FERPA and not HIPAA. The annual notification process must ensure that parents understand their rights to request and inspect their child's record, request to amend the record if they believe it's inaccurate, disallow any disclosures of directory information, and file a complaint with the U.S. Department of Education regarding the district's failure to comply with FERPA. FERPA gives parents certain rights regarding their children's education records. These rights are an important part of FERPA. A parent is defined as a birth parent, a legal guardian, or an individual acting as a parent in the absence of a parent or guardian. These rights transfer to the student when they reach the age of 18 or attend a school beyond high school level. Students to whom the rights have transferred are called eligible students under FERPA law. Parents have the right to inspect and review their child's education records maintained by the school, but these rights are limited only to their children. So, if the education record includes information about other children, that information must be removed prior to disclosure. Correspondingly, eligible students also have the right to inspect and review their own education records. School employees should remember to consult with both custodial and non-custodial parents on education matters involving their child. As specified by FERPA, non-custodial parents have the full rights as parents for access to student records, unless there is a court order, state law, or legally binding document that specifically revokes these rights. When parents or eligible students request inspection and review of education records, the school district must respond within a specified amount of time. Federal law stipulates that the requested information must be provided within 45 days. Some states require an even shorter time frame. School staff should never destroy education records if a request for review is pending. It's important that all school employees recognize the importance of a parent's request for inspection and review of their child's education record, as well as the time limit. Always notify your school's administration of such a request, acting in accordance with your district's policy. School professionals should also recognize that the time limit to supply a record to a requesting parent is to be honored at all times of the year. One district errantly informed a parent who made a request in June that the records could only be made available after summer break in September. FERPA doesn't permit deferring a request for inspection and review beyond 45 days under any circumstance. Schools are generally required to give copies only if failure to do so would effectively deny access. An example would be a parent who does not live within commuting distance. In these circumstances, schools can arrange a fee for the copies. Parents or eligible students have the right to request that schools correct education records that are inaccurate or misleading. If the school or school system elects not to amend the record, the parent or eligible student has the right to a formal hearing. However, according to the U.S. Department of Education, while the FERPA amendment procedure may be used to challenge facts that are inaccurately recorded, it may not be used to challenge a grade, an opinion, or a substantive decision made by a school about an eligible student. Typically, a school district will designate a hearing officer to further consider a request for correction or amendment. If a district hearing is requested, the hearing officer will review and consider documented evidence about the record and render a ruling. The hearing officer's decision is final. After the hearing, if the school still decides not to amend the record, the parent or eligible student has the right to place a statement with the record setting forth their view about the contested information. That statement must then stay with the record. The school must disclose the contesting statement whenever it discloses the record. School employees should remember these facts about FERPA and parental notification. FERPA law requires that local education agencies notify parents annually of their rights. Schools should always avoid disclosing personally identifiable information from the student's education records to third parties. Law enforcement, medical, alumni, employment, and sole possession records are not considered education records. And FERPA violations can put funding sources at risk, as well as create legal problems for the district. Finally, school employees should remember these points about parents' rights to inspect and review records. Parents have the right to inspect and review education records for their children. Schools have 45 days, or less in some states, to honor that request. Parents can request that records be amended. And if the school or district denies that request, the parents have a right to a formal hearing with a district-appointed hearing officer. FERPA is a law that ensures parental access to their children's education records while protecting the confidentiality of those records from third parties without parental or the eligible student's consent. When disclosing students' education records, you must be mindful of their personally identifiable information and remove it when necessary. Be sure to review the specific instances in which education records and personally identifiable information may be disclosed without consent. It's important that parents and eligible students are notified of their rights under FERPA and that your school's administration is always notified of requests for education records, acting in accordance with your district's policy. After taking this course, you should be able to understand the importance of confidentiality and recall the rules governing disclosure of students' personally identifiable information. And recognize the rights of parents and eligible students to access and review education records maintained by the school district. Review these points and repeat this course if needed.